Welcome to Indiana Newsdesk. I'm Joe Wren. Well, an Indiana resident who won a U.S. Supreme Court victory earlier this year in a case challenging police seizures of personal property still doesn't know if he'll get his car back. That's a decision that will likely come from Indiana's Supreme Court. As Barbara Brosier reports, justices heard oral arguments in the case this morning.
Police seized Tyson Timms' $40,000 Land Rover more than 5 years ago because they say he used it to transport a few $100s worth of drugs. It's a process called civil forfeiture, which allows police to take personal property they suspect was involved in a crime, even if someone is never charged. Timms challenged the seizure, arguing it was disproportionate to the crime.
It's not about getting my truck back, for me. That hasn't been the case for me for a long time. For me, this is principle. They shouldn't be able to do this to people.
The U.S. Supreme Court took the case up after Indiana's Supreme Court ruled it wasn't clear whether the Eighth Amendment's ban on excessive fines applied to states. The nation's highest court ruled it does. So Timms' attorney went back before Indiana's Supreme Court today to argue police taking the Land Rover was excessive.
They would treat, under the excessive fines clause, Pablo Escobar the same way they would treat Tyson Timms.
But the state of Indiana says the excessive fines clause doesn't require seizures to be proportionate to the crime, and that police were justified in taking the car because Timms used it to transport drugs.
It is not a test that is designed to discriminate based on the type of property involved. It's designed to get at the property that is, as tradition would have it, is the guilty property and get it out of the criminal enterprise.
There's no timeline for the court to issue a ruling. For Indiana Newsdesk, I'm Barbara Brosier.